Hello everyone, myself Yusra Khan, co-convener of Lawlicious. Lawlicious is an organizing committee founded by Mr. Vivek Dixit, which provides knowledge about internships, debate, and moot court competitions. It focused on promotion, legal awareness through webinars and competitions for students and scholars, which is beneficial for all law students. Now, I would like to introduce our keynote speaker, Dr. Indrajit Acharya Sir. Dr. Indrajit Acharya is currently working as a faculty member at multiple reputed institutions, including Umesh Chandra College, University of Kolkata, and JIS University of Kolkata. He holds a PhD in law, LLM contractual law, and BA with over 9 years of teaching and 9 years of practice experience. He has taught subjects like business laws, criminal laws, constitutional values, and international criminal law at various law colleges. Dr. Acharya has practiced law at Kolkata High Court and Alipur Court, specializing in both civil and criminal litigation. He has authored and edited multiple books on business and company law, published several research papers in national and international journals. He has been invited as a guest speaker at numerous seminars. Dr. Acharya is also an active member of Bar Council of India and other professional organizations. He is passionate about teaching research and uphold the principle of law in both his professional and personal life. Over to you, sir.
Good evening, everyone. Myself, Dr. Indrajit Acharya. First and foremost, before extending my thoughts on new criminal laws, I would like to extend my thanks to the organizing committee, organizing team of Lawlicious, and a special thanks to Vivek Dixit for giving me the opportunity to share my thought here. So, without wasting any further time, I would like to share the screen first and a PPT regarding this subject matter. Right.
Sorry for the disturbance, sir, but your voice is not clear. Sir, your voice is not clear.
First of all, tell me, is the screen visible to all of you? Is the screen visible to all of you? First of all, tell me.
Yes, sir, the
Yes,
screen
sir.
is visible, but your voice is not
Uh,
clear.
okay, okay. Is the PPT, is the slide visible also?
Yes, sir.
Okay, okay. Thank you. What about the voice? Am I audible clearly now?
Yes, sir, now it is audible.
Thank you, ma'am. So, without wasting any further time, I would like to start with the given discussing topic of ours today, that is comparative analysis between Indian Penal Code and Bhartiya Nyaya Sanhita. So, basically, uh, the Indian Penal Code, which is established in 1860, has served served as the bedrock of Indian criminal justice system, or for that say criminology system, for over a century. It was drafted during British colonial rule and has laid down comprehensive legal classifications and corresponding punishments for various or numerous kinds of offenses. However, although over the decade, this Indian Penal Code or IPC has undergone many an amendment, many a repeal, many a changes, which is very much adjacent, which is very much part and parcel of our daily life, especially in socio-economic offenses, our offenses relating to body, property, technological landscape, etc. But because of some Supreme Court rulings and the recommendation of Law Commission reports, there have been significant changes that were order of the day in terms of IPC. And such kind of changes, such significant changes that was recommended by Law Commission of India, that includes like decriminalization of consensual same-sex relationship, adultery, attempt to commit suicide, alongside region-specific amendments, which we usually call as state amendments by individual states, respectively. But because of severe efforts, because of intense efforts, as IPC has struggled to keep pace, to have a need, to fulfill the need of the contemporary issues like cybercrime, organized crime, terrorism, which were very much needed in terms of the society. Recognizing the need for a modern and efficient legal framework, this Bharatiya Nyaya Sanhita was passed by Parliament in the winter session, and accordingly, it received presidential assent on 25th December 2023. Now, this code is reviewed by the Standing Committee of Home Affairs Ministry of India also. Accordingly, it aims to replace the IPC. I repeat, it replaces the IPC while retaining its core provision, adding new offenses as well as increasing penalties for various crimes. It thereby aligns India's new criminal law with present day realities. BNS, Bharatiya Nyaya Sanhita, it comes into force from 1st July 2020. But one section that was not incorporated, that was not came into force from 1st July 2024 is 160 subsection 2. Now, one thing we must keep in our mind, this BNS in comparison to IPC is very much concise, is very much lesser in terms of number of sections. It has 358 sections in comparison to 511 sections of IPC. Because although the number of sections has been lesser, but the offenses that have been covered in BNS is more than the offenses, the nature of offenses, the types of offenses that were covered by the IPC. The new offenses that BNS introduces to us are organized crime, petty organized crime, terrorism, terrorist activities, etc. So this is the new nature of offenses that uh, BNS has given to us. Next thing that I would like to mention, the need, why this was required. What was the necessity for which the IPC was replaced? So I have pointed out, there are many, but I have pointed out the five of them only. First of all, outdated provision. Because we all know that IPC was drafted under the British colonial system, under the chairmanship of Lord Macaulay. So from that moment onward till today, we have gone through our Indian socio-economic structure, our political scenario, our parliamentary scenario, our nature of offenses have gone through various changes. So the provisions of IPC that were very much outdated, so there was a need to change the present day legal system. So, a legal system which is very much adaptable, which is very much conjoined with the present day legal system. Now, the next thing that comes to our knowledge is the colonial legacy. As we are already talking about, as we are always talk about, make in India, anything that is our very own. So we tried to come out of the British colonial administration also in terms of our legal system, in terms of our statutory provisions. So Colonial legacy, to coming out of colonial legacy was the another need for which BNS has been drafted. Next, complexity and ambiguity. In terms of the languages, in terms of the language that has been legal terms that have been used in IPC, as because there was shadow of British English, there was British language, sometimes to a marginal people, to not so a knowledgeous person, to not so a educative one, educative citizen of our country, it was bit complex, it was bit ambiguous. So it was not something that a person who is not a student of law, where law is not his or her cup of tea, the person is not very much familiar with, very much go-to kind of a thing for him or her. Next thing that has come to my mind is our IPC has traditionally been more offender centric. So IPC more or less talks about offender, but this BNS more or less is talking about victim. So basically, it is a victim centric approach rather than offender centric approach. And last but not least, I have mentioned this is not the exhausted list. Again, I am repeating my own words in terms of the need for replacement. Procedural inefficiencies. So we all know IPC was the substantial part of the criminology system, and the procedural part was CRPC. And we all know somewhere down the line there was a complete nexus, there was a complete channel between IPC and CRPC. Both are inseparable in terms of prosecution, in terms of suit, trial, etc. But this IPC and CRPC, somewhere down the line, as the days were going by, as the new and newer nature of offenses are coming in our society, some gap were widening in between IPC and CRPC. So IPC and CRPC, they were lacking in terms of procedural efficiencies, and here the need for BNS has very much become evident. Accordingly, it was necessitated a more efficient framework which BNS has tried to give us, has tried to present to India. Now, the thing is types of punishment. We all know in section 53 of IPC, the types of punishment like imprisonment, like capital punishment or death sentence, like fine, like forfeiture of property, like life imprisonment, be it rigorous or simple, they have been mentioned. These all types of punishment are still there in BNS, chapter 2, section 4. This is still very much there. Now, the new thing that has been added, that is community service under the head of punishment, chapter 2 of section 4 of BNS. It was not there in IPC. This community service is placed under BNS as one type of punishment. Next, here I have mentioned from this slide onward, you people will be able to see I have mentioned few offenses that have placed under BNS and which were not there in IPC. First and foremost, economic offenses. In present day, our country is witnessing, is experiencing monetary economical offenses very much. It is very much evident that monetary offenses in terms of bank, in terms of investment scheme, in terms of any cheat fund, Ponzi scheme, they are very much forgery, counterfeiting, etc. These are very much go-to sort of offenses for our country. So, in order to tackle these kind of things, to tackle this kind of economic offenses, BNS has tried to put in some newer types of things that were not there, those were not there in IPC. Some of them are criminal breach of trust, forgery, counterfeiting of currency note, banks note, government stamps, etc. Now you people will definitely say, okay, sir, criminal breach of trust, forgery, counterfeiting, these all were there in IPC. But These were not there under IPC under the head of organized crime, right? This organized crime, when we will go through international criminal law, as we call ICL, we all will be able to know what organized crime is. Organized crime is something that we are experiencing every day all over the world, like drugs, like terrorism, like um, forgery, etc. We are experiencing every day. Human trafficking, child trafficking, these all are part and parcel of organized crime. But till the invent of BNS, India only have heard of these economic offences, but we were lacking in terms of any stringent provisions to tackle this kind of offences. We always have found ourselves in the wrong side in terms of tackling this organized crime. Now BNS have come out with a provision, with a chapter, with a punishment for the offenses like organized crime. So although IPC does have, did have criminal breach of trust, forgery, counterfeiting, etc., but it did not have the term organized crime labeled with it. And again, in later on, we will discuss only today that government stamp, bank notes, etc. These were not there in IPC. These were not covered under the IPC. These were not there in IPC. So, although counterfeiting, forgery, etc., were there in IPC, bank notes, government stamp was not there, right? So accordingly, hawala transactions, mass marketing from, these are all new things that have been added. Wait, one more thing here I would like to mention: this organized crime, what I have just mentioned, it is very much there under section 111 of IPC. 111 of IPC, very much there, and the 112 112 of BNS covers petty organized crime. So basically, organized crime have been categorized into two heads in BNS. One is petty organized crime, and another is general organized crime. Petty organized crime is covered under 112, and the main organized crime are covered under section 111. Now we are coming to cheating. Again, we will talk about yes, sir. It was also there under section 415 to 420 of IPC. But BNS again has come out with some different ideas. First of all, the degree of cheating. Previously, cheating was generalized in terms of 415, 416, cheating by personation, etc. Cheating in related to property 420, it was generalized. But what BNS has come out with new is to judge the extent of gravity of cheating. So accordingly, the degree of cheating, based on degree of cheating, the punishment has varied. First of all, we have to judge the harm, the injury the victim has suffered. Basing on the magnitude of the injury, graveness of the harm victim has suffered, the quantum of punishment will be different. You could be able to see here I have mentioned whoever cheats will be punishable with imprisonment up to 3 years or fine or both. It is very much there in IPC also. But if we go into further detail, whoever cheats with knowledge that he is hereby likely to cause a wrongful loss to the person whose interest in the transaction to which the cheating relates, such person would bound to protect shall be punishable with a term extended to 5 years or fine or both. So the person whose interest is getting hampered because of the cheating, who has an interest over the transaction that has taken place under the head of cheating, that person will be punished not in a flat way as is mentioned, like 3 years imprisonment or fine or both. He will be or she will be punished with 5 years imprisonment or fine or both. Now, again, if a person cheats and dishonestly induces the person deceived to deliver any property to any other person, means a third party is getting involved. I am not practicing, I am not exercising cheating upon a second one. There is another involvement of a third person. Who is the third person? Who is being asked by me to deliver a property to someone else, or to alter the property, or to destroy the property, or to part with the property. So, if a third person, if another new person is getting involved in terms of cheating, then the quantum of punishment will be extended up to 7 years and shall also extendable to fine. Okay, it is not or, it is both 7 years imprisonment and fine. Okay, so this magnitude of injury or harm was lacking in terms of IPC cheating like 415, 416. Now, the next thing that has BNS has introduces, that is offense against body. Again, this is something that we already have gone through in terms of IPC. But in terms of organized crime, if a person has injured himself, has got hurt because of any organized crime, may not be resulted into death, organized crime or terrorism activity. It could be hurt, it could be grievous hurt, it could be abatement of suicide, it could be assault, etc. It could be any kind of attack on the basis of any race, racism, birthplace, language, etc. Then either the person individually has attacked, then the person will be individually be punished. And if the offense, if the wrong has been committed in a group, then the punishment will be every member of the group. The punishment will be inflicted on every member of such group, who will be punished with death or with imprisonment for life, and also liable for fine. So basically, the thing is, even a racism has been leveled as an offense against the body, which was again missing in terms of IPC. Okay, so apparently it may seem to that offense against body was something that we all are aware of, we all are knowledgeous of, but the nature of the offense has gone a different level in terms of coverage under BNS. Okay, so this is a new offense that has been covered under the chapter offense against body. Next, organized crime. Few minutes ago, I told you people, one of such organized crime is terrorism or terrorist. Previously, we leveled, we charged, we framed charge sheet under sedition, 121, etc. Now, this terrorism has got an individual section of its own under BNS, that is 113. So no more it will be called, terrorism activity will be called as sedition or as a seditious activity. No more it will be called outrage of war against any sovereign state or sovereign country or any democratic government, etc. It will be clearly termed as terrorism, and now we can proudly say our country has a expressly section, an exclusive section under BNS, that is section 113. Now, another thing you people will find, I have mentioned here, that is section 106 subsection 2, that makes escaping from the site without reporting any rash act not amounting to culpable homicide leading to death of the person to any police officer or to magistrate. This is a very important thing. This is a very relative sort of a thing in our daily life, because while going through road, while passing through road, we are able to see that any man, any person is in dire state, and he or she may urgently require some kind of medical attention. But because of any kind of procedural tyranny, legal tyranny. We try to escape those things. अरे यार ये झमेले में कौन पढ़ना है, किसको पढ़ना है, छोड़ो. This generally is our mentality. Now, this offense against body under BNS has clearly mentioned that if any person escape from the site without reporting any incident to the magistrate or to the local police officer or for say any traffic sergeant riding bike or sitting or standing on the road, without reporting them any such rash activity, any such dire state of any person, that same will be immediately punishable. That person will be immediately be punishable with 10 years imprisonment and could be extended up to fine. It is a new sort of a thing that has been mentioned here in IPC. Sorry, IPC, sorry, beg to be apologize. Will BNS. Next thing, sexual offenses against women. Again, something that we are very much aware of in terms of IPC, more fully after the infamous Nirbhaya rape case, Criminal Amendment Act 2013, offenses like stalking, voyeurism, acid attack, outraging of modesty, these all came under the periphery of IPC in the Criminal Amendment Act 2013. Now, in of late, our country are witnessing very heinous offenses, heinous crimes that are happening against the woman. And to worsen the situation, women, even a minor girl, even a under 18 girl, they are also getting victim. So the threshold for victim has been classified as minor in gang rape cases for 16 to 18. We all know that Criminal Amendment Act 2013 has clearly mentioned even a consensual sex under the age of 18 will be termed as a rape. This provision has remained same in BNS. Now, BNS, along with that provision of IPC or Criminal Amendment Act 2013, have added sexual intercourse by employing deceitful means. Sexual intercourse by employing deceitful means or by making a promise to marry a woman without any intention of fulfilling the same can be punished up to 10 years. In this point, in this juncture, I would like to refer a case reference, that is Bodhisattva Gautam versus Shubhra Chakraborty. I think many of you have already knowledge about this case. Those who don't have, please go through this case in Google. It's a very, very famous case in India in terms of false promise to get married without any intention of fulfilling the same. This is a very, very famous case of an infamous incident. Okay, so IPC, sorry, BNS has given this offense also a shelter. What they are saying, even a person has found to give false promise to marry a woman, then that person can be punished with imprisonment up to 10 years. Again a change that BNS has introduced, which was not there in IPC. Okay. Now, the offense has been headed as false promise to marry. Now, section 70 subsection 2, which is a very important section. Gang rape of a woman under 18 years of age. I repeat, gang rape of a woman under 18 years of age. Yes, the offense is not a new to us. This is very much a old sort of a thing that is happening in India. That has already happened in India. But underage gang rape was termed as only gang rape in IPC. But under BNS, gang rape to a minor girl has covered a different punishment. It is not categorized as a normal gang rape. The punishment is life imprisonment or imprisonment for remainder of person's natural life, or with fine, even with capital punishment. The offense, again I am repeating my own word, this offense is not something new to us. Even in IPC this offense was covered, but this offense under BNS has given a separate punishment, a separate section. So underage minor girl getting gang raped is not to be treated as a normal gang rape. He or she is, sorry, the offenders will get a punishment, life imprisonment extended up to remainder of person's natural life, or with fine, or with death sentence. Again, a new introduction, a new byproduct of BNS. Now, organized crime, terrorism, that I have already talked about. Now coming to sedition. Sedition, again, it is very familiar to us. It is not something we have not learned of, but now the mannerism of committing sedition. I repeat, the mannerism of committing sedition that was not there in IPC, that was lacking in IPC, has been covered, has been fulfilled under BMS. Here, even the verbal or written communication, any communication that has been made in electronic means, any kind of monetary or financial transaction to giving aid for the commission of sedition activity, funding the terrorist groups, funding the extremist groups, also amounts to sedition, along with criminal conspiracy, abatement, etc. Those funding persons, those financiers will also be leveled as seditious activity under new BNS. Even as we know that more or less these organized criminals, these terrorist groups, this extremist group, they try to use satellite phones, WhatsApp video call, which don't have any call record, which don't have any backup. Even they have done so to communicate with each other. And our very own intelligence agencies like RAW, IB, if they manage to crack them, to crack the code, those organizers, those offenders, those terrorist groups will get punished maximum of 7 years up to extended up to life imprisonment, and can be leveled with fine also. Okay, this section has increased the maximum punishment from 7 years to life imprisonment. Okay, and we all know, along with seditious activity, there is another act in India that is known as UAPA Act, Unlawful Activities Prevention Act. So along with sedition, UAPA Act can also be leveled against those persons. Okay, so it is not something that only IPC can be leveled. UAPA Act can also be leveled as per the amendment 2019, read with UAPA Act. IPC, sorry, BNS read with UAPA Act. Terrorism, as I mentioned already, it is there in 113 of BNS. Okay. This one. Organized. I have already mentioned what organized crime is in terms of international criminal law. Now, this BNS has extended the scope, has extended the periphery of organized crime. It has covered कॉन्ट्रैक्ट किलिंग, जिसको हम लोग बोलते हैं सुपारी किलिंग, लैंड ग्रैबिंग, फाइनेंशियल स्कैम्स, cyber crime conducted by syndicates, criminal syndicates. These have covered under BNS also. These were not there in IPC. Okay, so abducting someone, kidnapping someone for the purpose of some ransom, for the purpose of extortion money. Okay, these also, other than kidnapping and abduction, as we have gone through in 359, 360, 362 of IPC, these have given a special place under BNS. The punishment has also been mentioned to lead to extended up to person's death or capital punishment. Now, mob lynching. Mob lynching. As soon as CRPC has given us the scope of arrest of a person by private person, arrest by a private person, we all started feeling ourselves. We all started to make ourselves as police. हम सभी police हैं. We can arrest anyone. We can give punishment to anyone. We can inflict any kind of torture upon them, etc. But mob lynching has become a punishment under BNS. If anyone or any group of person or any community of person have been found guilty for mob lynching, can be punished up to 7 years, extended up to life imprisonment or even death sentence. So we have to be very, very, very cautious while trying to take law in our own hand. But here I would like to say, arrest by a private person, as was mentioned in 43 of CRPC, as is right now mentioned in BNSS, that provision has remained intact. But in terms of arresting anyone, we must not exceed the bar, the limit that has been set to us, that has been forwarded to us by the BNS. So mob lynching is very much a new type of an offense in terms of covering. Mob lynching is not something we have not heard of. It was very much there, but it was not expressly there in IPC. So right now it is a very much an offense, a convict. Any extrajudicial killing, any group carrying out any extrajudicial killing will be leveled as a mob lyncher and will be punished accordingly. Now, offense against public tranquility. It is again something that we have already have a fair idea while after going through IPC, but BNS simply has extended the scope, the periphery of public tranquility. We all know about unlawful assembly. We all know about rioting, affray. These all 141, 146, 159 of IPC, we all are aware of. But along with those two sections, mainly two sections have been added, that is 196 and 197. And one thing I would like to mention here, in terms of covering public tranquility, even the electronic communication, WhatsApp message, Facebook Messenger, any kind of insightful messages, any kind of messages that could easily hamper the public tranquility, the public peace, have been leveled, have been covered as an offense under section 196 and 197. Okay, this could be committed by any individual, this could be committed by a group of person, anything. The mannerism could be spoken word, the mannerism could be written word, the mannerism could be electronic communication, any visible representation, everything has been covered. And another thing, 197, any imputation, assertion prejudicial to national integration, affecting the sovereignty, affecting the integrity of the nation, of the country. Again, verbal, written, electronic, oral, everything is termed as an offense against public tranquility. Now, another thing, criminal defamation. We all know under 499 and 500, defamation and the punishment of defamation has been mentioned. Now, section 356 of BNS have simply consolidated both the sections, and the punishment of community service, as I mentioned in section 4, types of offenses, chapter 2 of section 4, have added a new form of punishment, the community service. I simply mentioned it just to give a reflection where it has been applied, how to apply this community service. That's why this section I have referred. But the nature of offense, but the punishment, everything has remained same, just with the IPC. Only the community service has been added for the offense of defamation. Okay. The last thing I would like to mention, offenses related to coin, currency, notes, etc. This is again something that was there in IPC, like counterfeiting, etc. But I have already mentioned few minutes ago that I would come to discuss it in a elaborate manner. Government stamp and coin, it was only currency note that was there in previous IPC. Now, even the coin, sikka, that has been covered here. Not only that, but also the stamp paper. Every state government have their own government stamp paper, their own very own stamp duty. If any counterfeit, has taken place in terms of जिसको हम लोग बोलते हैं ना स्टैम्प स्कैम, जो वो तेलगी वाला जो स्टैम्प कैंप हुआ था, so no exclusive provision was there to hold them responsible. Now this BNS has covered those kind of scams, stamp scam. And also along with currency, the coins, the sikka, that have also been covered as a offense relating to coin, currency, notes, etc. under section 178. So this is from my end. Now I would like to hand it over to the host, and if anyone having any question, any doubt to clear, I am open to it. You may ask. May I
Thank
stop
you,
the
sir,
sharing?
for your thank you
May I
so much, sir,
stop the
for your
sharing now?
wonderful session. Thank you so much, sir, for your wonderful session. We have learned a lot from your session. Now, any one of you have any doubt, then you can switch on your mics and ask, or if not, then you can ask in chat box session. I don't think that anyone have any question. And I want to say something that everyone will get certificates only after attending all the three webinars. We were not giving certificates today. We will give certificates after attending all the three webinars. Thank you so much, everyone.
Okay, thank you everyone. I'm leaving as of now. See you in the next week to discuss about BNSS, that is so-called CRPC. Okay, thank you everyone. Good night.
Thank you very much, sir.
Thank you. Thank you. I'm leaving.
Thank you, sir.